Hey, so we're here again, and today we're going to talk about a corporate case, medical malpractice case. Six, it was just decided in 2024, so a very recent Washington Supreme Court case. Mallory, give us a quick rundown of that case.
Yeah, so basically, this case is plaintiff Cindy Essex, who passed away. She was admitted to the ER for extreme pain in her left shoulder, 10 out of 10 pain, really terrible. The doctors that treated her, Dr. Davis and Dr. Crute, treated it like a GI issue. They did a couple of scans and then sent her to another specialist and didn't catch very important signs that she was actually experiencing necrotizing fasciitis, a very aggressive soft tissue infection, very deadly. They did not diagnose that in time, and that delayed diagnosis and treatment ultimately resulted in her passing away. So that's the basics of what happened to Cindy.
Her estate ends up suing the hospital, and the hospital defends by saying, oh, well, the ER doctor was at fault. The hospital doesn't have any fault because the ER doctor is an independent contractor. They're not our employee. They're a
Right.
total independent contractor. What does the court say about that?
The plaintiff's argument is they should be held vicariously liable under a theory. They offer a couple of different theories, but the one the court focuses on is that the hospital has a non-delegable duty to perform emergency services and make sure that the people performing those services, whether they're employees or not, are doing so competently. And the court says that theory succeeds. There is a non-delegable duty that hospitals have to perform these emergency services. And even when they delegate that to contracted doctors, they cannot delegate that liability, that responsibility that they have to the patient.
Yeah, this has become a trend where hospitals, when they hire their ER doctors, they do it via independent contract status because they have a lot of benefits in doing that. These hospitals are big corporations and they want to minimize their liability. And one of the ways that they were doing that were they were hiring independent contractors and saying, well, these are not our employees. We don't manage these people. They come to work when they want to come to work. The way that they handle their emergency room doctor, their skills are beyond us. We don't have anything to do with that. All we do is we pay them on an hourly basis and they can come and go as they please, so we don't manage them. But obviously, the courts in this situation gave a couple of different policy reasons why those hospitals cannot delegate that duty and responsibility of having above reasonable standard medical care. They can't just say, that's your responsibility, doctor, that they have to retain some of that responsibility, or they can't delegate all of it to the ER doctor. And what were some of the policy reasons why?
Yeah, so the court actually opens the entire opinion talking about sort of the expectations that patients have when they go to a hospital. Later on, when they're doing their analysis, they talk about sort of how medicine has evolved over time. It used to be that you would hire a personal doctor who would come to your house and see you, and you'd have a personal relationship with that one doctor who knew you very well. Whereas now, it's very common for people to go to a hospital and not have any existing relationship with the doctor there. They're going to the hospital expecting to receive care that the hospital is providing. The hospital is providing the doctor, the nurses, and we, the patients, don't really have an existing relationship with the doctor anymore. So they really focus on what your expectations are as a patient going to the hospital and the fairness when you are getting negligent care that you can't sue the hospital, right? It feels unfair that you would go to a hospital, get negligent care, and not be able to sue the hospital just because the doctor was a contractor.
Yeah, like if you had an issue, your knee was injured or badly hurt and you go into the hospital, you wouldn't ask, hey, is my doctor employed by the hospital? You wouldn't go through
Right.
that analysis to try to figure out if it's a hospital employee or not and whether or not there's some sort of guarantee of good care because, yeah,
Right. And especially in these emergency situations where you're going to receive emergency care, your main priority is I want to be taken care of. You're not
yeah,
worried about these relationships between the hospital and the doctor and you. All of those things are over your head really in that moment.
yeah, this ruling has further implications, not just dealing with the hospital staff and whether or not they're employed or as an independent contractor status with the hospital, but it goes further than that. For example, if you own a law business and you have multiple lawyers working for you, if they're all independent contractors and a lawyer makes a mistake, as owners, we can't say, oh, but that lawyer happens to be an independent contractor, so we're not on the hook for what the lawyer does. Chiropractors or CPA offices, you go to a CPA office and you're working with one particular CPA and you can't sue the firm because the CPA is an independent contractor. That would make it
Right.
very difficult for people to have to suss through all that and make it a part of their analysis. That's kind of similar when you go to the grocery store and you buy a particular cereal or whatever and there's something in it. Do you have to just go after the manufacturer, or can you just sue the Safeway because you bought it at Safeway?
It's a great example because, it's about not having to go searching for the proper defendant when it's obvious
Yeah.
where you got the cereal from. And so it makes sense the court would make that policy judgment that we don't want you to have to go searching for who's responsible here. When you went to the hospital and you got negligent care, obviously they're the ones responsible.
Yeah.
Yeah.
Yeah. Part of that policy reason is for the benefit of the people who are using that service so they don't have to go through this whole analysis. Yeah. So they made it pretty easy on us.
Yeah. And I do think it's interesting to see the ways that this could be extended to different fields, like you were talking about. I do think that the court gave a lot of freedom to do what common sense allows. So in this case, they focused a lot on the regulations specifically for hospitals who provide emergency services to say, when we read these regulations together, we find that there's a non-delegable duty here. And they also mention the question of inherent function. One of the arguments that the plaintiff makes here is that the hospital should be found vicariously liable under an inherent function theory, meaning the doctors, even though they're contractors, are performing an inherent function of the hospital and therefore they should be held responsible. The court does not comment or conclude anything about whether the inherent function can be its own independent basis for vicarious liability, but they do say that's a very important, relevant factor in determining what non-delegable duties are. So
Yeah.
because the doctors are performing that inherent function, it makes the case stronger that this should be a non-delegable duty. And that analysis could potentially also be extended to other fields.
Yeah, because when you go to a hospital, the essence is to get taken care of your health needs. And the
Right.
emergency room doctor is kind of it just encapsulates everything, every purpose of the hospital. If it was
Right.
something less central to what a hospital does, like, I mean, I don't know a good example, but like, let's say the janitor mopped the floor and the floor was wet. That's a different issue. The reason you're going to the hospital is to get good care. If you don't, you can't avoid your responsibility through these legal techniques. Because if you could, then every hospital would just force all the doctors to be independent contractors. Then they could hide from any liability.
Right.
And and so could all these other companies. You start a company, let's say you're a painting company, but you hire all your painters via independent contractor. And if you mess up somebody's paint job, you say, well, I mean, that's not my I mean, that's the
Right.
independent contractor. So you could sue him who's got very little money. It's a way to hide from your responsibilities through these technical legal issues. And I don't think the court likes that.
Yeah, and I think it's interesting to compare the policy analysis here to the case we were talking about last time, the dog bite case, where the court made the opposite judgment that landlords shouldn't be held liable for the actions of their tenants, right? Which we can see why that's different because we can sort of common sense when you're trying to hold the landlord liable for something the tenant did where the landlord didn't have any control, it makes sense that we wouldn't want to hold them liable because you're really just looking for the deep pockets. We were talking about how
Yeah.
the landlord has a deeper pocket. And so we're actually we know who's responsible. The tenant's responsible, but we're trying to get the deeper pocket. Very different. Clearly, this is the hospital's responsibility to manage these people, whether they're employees or not. The hospital is performing this duty of emergency services and has to have some oversight over the people that are doing that. And you can see why that would apply to different fields as well.
Yeah. This vicarious liability is almost like strict liability. That doctor is working for the hospital, and the hospital gets the benefit of having that doctor work at their company and be under their branding and policies and everything like that. So it's like if the emergency room doctor was negligent, then almost automatically it makes the hospital negligent for the emergency doctor's error because that emergency doctor was doing their work for the benefit of the corporation. Whereas,
Right.
yeah, like what you were saying in the dog bite case, that's not necessarily the case.
Yeah, and I think that's also why the court focuses on the regulations legally required of hospitals who provide emergency services, because it's clear to the court that the legislature, when enacting these regulations, was intending for the hospitals to be responsible for the safety of the patients there, right? And in order to do that, you have to have oversight over the people providing the services, and that
Yeah.
includes contracted doctors.
Yeah. It's interesting that this is a 2004 case because these kind of issues have been going on for quite some time. And obviously, courts have ruled in different ways. The Supreme Court wanted to clean that up. So that vicarious liability portion is very solid. Prior to that, we used to use different techniques like corporate negligence, like the hiring was poor, they were trained poorly, they're overworked, or they had bad internal policies. Like there was all these reasons that we would be able to find that the hospital was negligent, even though the doctors were really the ones that were negligent. But now we have a much cleaner avenue as plaintiffs' lawyers to find that the hospital's negligent just by virtue of the emergency room doctor being negligent, disregarding whether or not they're an independent contractor. So we don't have to go through that analysis anymore.
Yeah, totally. And it makes a lot more sense the way the court has cleared it up. There was an argument in this case for corporate negligence based on the actions of the nurses who were employees of the hospital. The nurses failed to report some of the patient's symptoms to the doctors in a timely manner, failed to recognize the severity of those symptoms. And so that was deemed a failure of their training, which was the
Yeah.
responsibility of the hospital. So in that way, the hospital was negligent themselves, not just vicariously, but in their training or lack of training of their nurses. But that wouldn't work for the contracted doctors because they're contractors coming in from outside. So the hospital isn't necessarily responsible for training them, but the court is saying you are responsible for having some oversight over them, even though you're not training them directly.
Yeah, a lot of people, when they go to an emergency room doctor, they're going to that particular hospital. The hospital has a brand that they're going to. And then for the hospital to then turn around and say, oh, well, that was actually these contractor groups. But you're not going to St. Joseph's or St.
Right.
Clair's because of the contractor group. You're actually going there because of the hospital brand. So they should be responsible for it.
Yeah, when I think about the times I've been to the hospital in the past year, I don't think about the doctor that treated me. I think about the hospital that I went to, right? The treatment facility. So really makes sense on a common sense level.
Yeah. So in the end, the policy is if you own a hospital and you're running a hospital, you're responsible for your doctors and nurses and their negligence. You got to pay up for that. Okay. Well, good. Thanks for doing this again, Mallory, and we'll see you next week. Essex versus Grant County.